There you go.
Okay, capacity to make a will. And we can whiz through this, I think, fairly quickly, because it's not difficult. It's just a matter of committing materials to memory. And age, you can have a look at that. 4.1, mental capacity. Yeah, right, let's spend a little bit of time on this. Basically, testator's got to know and approve of the contents of the will. And the test for testamentary capacity is pretty well, I don't know whether you've done English succession, but it's the same as England, really. Both Jersey and Guernsey have sort of taken English law. So I've got some cases here. Davis and Sterling, well, that's the Jersey case. Trigg and Craft, again, is the Jersey case. But Banks and Goodfellow, that old case of 1870 with Chief Justice Coburn in it. And that's the English case, of course. And there's that lovely quote at the bottom of page 22 or on 4.1. It's essential to the exercise of such a power that a testator shall understand the nature of the act and its effect, comprehend the extent of the property of which he is disposing, able to comprehend and appreciate claims to which he ought to give effect, and with view to the latter, that no disorder of the mind shall poison his affections, pervert his sense of right, or prevent the exercise of natural faculties. No insane delusion shall influence his mind, disposing of his property, and to bring about a disposal of it, which, if the mind had been sound, he wouldn't have made. It's also, I think, Davis and Sterling, the Jersey case, remember, approved Williams and Wills. And at the top of page 23, there are 3 points, which really, those 3 points understand that he's given his property to vulnerable objects, etc. Those actually all come out of Coburn's quote. There's a Privy Council case of Armachand that you can have a look at. I don't really think there's much more I need to say. I think the only other thing I ought to say is that the level of understanding when you sign the will isn't as great as when you're actually given instructions. So I think your mental capacity sort of deteriorates in the interim. That's not necessarily fatal. Also, you look at things like the health and the life of the testator, whether what he's doing in the present will is a great departure from what he's done in the past. And to be perfectly frank, it doesn't really matter whether he understands all the technicalities. We're not expecting him to be a lawyer. He's just got to have, you know, a sort of general understanding that he's making a will and sort of roughly what's happening in that will. Lucid intervals, if somebody suffers from mental illness that has lucid intervals, he makes a will in lucid intervals, that's absolutely okay. And the burden of proof, basically people are presumed to have capacity unless evidence is adduced to the contrary. And the only thing I can say is that if somebody has actually suffered previous mental illness, then the burden of proof is, I suppose, going to change a little bit. It's going to be greater in that situation. Practical point, I can't remember. Yes, I did put a practical point in here. I don't know what you do in practice, but if there is a doubt about somebody's capacity, I want some medical evidence or something, a letter from the doctor. So, I mean, I don't know what you do in practice.
So I think it's not just if there is any question as to capacity. I think that the golden, if tactless rule is that if you are dealing with somebody who is aged, and of course nowadays, as I get older and older, I find that I think old people become increasingly more remote. You know, when I was, I'd have thought 50 was old.
No, absolutely not.
When I was a teenager. No, correct.
No.
And now, you say, well, it's obviously a young lady.
Absolutely.
I have got a client at the moment who's 93, and I thought that probably is getting on a bit.
No, wait till you get to 70 odd then.
Maybe I'll have a different view.
Yeah, you will.
So if I'm dealing with somebody who, how did I say it to her? Because obviously you can't say to a lady, you know, you're old and therefore you need to. I say, I think I said, because when you're dealing with somebody who has celebrated as many birthdays as you have, it's a good idea to have some evidence as to capacity.
They're writing that down, Russell. I just noticed that they're writing that it down.
Not because, I mean, and this is genuine. This lady is obviously very with it and pricey. But she is looking to exclude a benefit, somebody who might be thought of as being within her likely largesse, and for very good reasons, she does not want this person included. I have said to her that if you want to challenge a will, the best way to do it if you're dealing with somebody elderly is to say, well, clearly grandma or great grandma did not have capacity. She didn't know what she was doing. Yeah. She could never have intended to exclude me because she loved me so much. So if you want the will to be robust, then my advice is, even when there is no doubt as to somebody's capacity, if they're doing something that's odd, or they're elderly, or they've suffered recent ill health, that it would be prudent to get a medical practitioner to sign off on the will. Now, one of the things that the doctors don't often understand, and a lot of practitioners don't understand either, is that the test of whether somebody is capable or not is a legal test. It's not a medical test, but it's a legal test that's informed by medical opinion. And I have seen lawyers who simply sign off saying, Betty's coming in to do a will for me, to come to do a will, can you confirm that she has capacity? Which is really unhelpful if you're a medical practitioner, because as we all know, the capacity to do anything depends on what it is you're doing. The capacity to buy a litre of milk is different for the capacity to enter into a life insurance policy. So you need to explain to the doctor what the test is that you're looking the doctor to confirm. And it's actually quite a detailed letter of instruction that you need to give to the doctor. But to answer your point, we get the doctors to either witness, act as one of the witnesses, or if they can't do that, to provide a contemporaneous note confirming that they've got this detailed letter of instruction, they've applied whatever test they've applied, and confirm that she's bright as a button.
Undue influence. Haven't got any cases on that. You said you had. Yes. You said you did have cases that pop up from time to time on undue influence.
Yes, I mean, the good news is they tend to be resolved out of court. Yeah. which is a positive thing for the families concerned. One thing I would say about undue influence is that there is, and you need to remind people that the key thing there is undue influence. Influence is not a problem. The fact that that the testator may be closer to one family member than another doesn't mean that the will is likely to be set aside. It is only where that influence is undue, where pressure is brought to bear, that changes the intentions of the testator that they wouldn't otherwise have. Practice point, and this happens all the time. Client phones you up, let us say that it's a male client, who says, my wife and I would like to make some wills. We're going to do mirror wills. We're going to leave everything to each other, and then we'll leave everything to the kids. Can you do that? To which you say, of course I can do that for you. I need to have some instructions from your wife. Well, it would be ridiculous. You can't, as a matter of professional ethics, produce a will for a testator or testatrix without their direct instructions.
Could I just ask you another point? Because I approach this in one way, but I think people approach it in different way. If you are doing mirror wills, I take it that you get them in individually to sign, etc., rather than together, or not?
I think it depends very much on the relationship, because Guernseys, you tend to know people. If I don't know them, I certainly will see them
Yeah, because in England we see them separate. You would not allow the two of them in, or I wouldn't. I mean, so no. I mean, you just have the one in, and you get them to do their stuff, and then the other one in because of undue influence. But,
so I might take initial instructions from them both,
okay.
but I will then certainly see them separately.
Yes.
And they might come in at the same time,
yes,
but
right.
I would then, ask husband typically
to leave. Yes, that's right. To leave the room. Yeah,
and wife come in, and then vice
yeah,
versa.
that's correct. Yeah, that's correct. Okay. Just wondered.
And of course, you make the point that you're making mirror wills now, but that doesn't mean that if you shuffle off first, your husband or wife can't tear this up and do something completely different.
Okay. Tutels and curatorships. I think we've got a problem question on tutel. You've similar wills. I'm not sure.
No, but in the UK you have
yeah, those are just normal.
Mutual and they are
and that's a constructive trust.
Yeah.
I assumed you didn't, but I could be wrong because I don't know. I mean, I haven't read the trust notes. Because of the way in which mutual wills operate, I didn't know. I mean, I didn't put anything on this at all. I just assumed Guernsey would not have them because, I mean, I agree with you. Once you've got it's all right until the first person dies. I mean, technically you've got a breach of contract because you've got the agreement not to revoke in the mutual will. But you've got the constructive trust arising on the death of the first, and I didn't know whether Guernsey would want to go that far. Because the problem is you've got a contract. That makes sense. You've got an agreement not to revoke. So you've got a contractual action on the breach of contract if they do revoke during their lifetimes, although damages would be nominal, if that makes sense.
So the 2011 law and the 2015 law both refer to contract to leave a will in a certain to leave property in accordance with a will in a certain way.
Yeah.
I've never come across it in practice.
No, the reason that's there is it's taken straight out of the 75 Act, which talks about the contracts to make wills and revoke wills or whatever, and you can.
Which are mutual wills, aren't they?
Not necessarily. You can have a mutual will in which, if you've got the mutual will, you can have them in substantially similar terms. They don't have to be, but they usually are, with a clause right at the beginning saying something like, I promise, or whatever you want to put it, not to revoke this will during my lifetime or something like that. But then you can also have a contract to make a will, which technically would be enforceable in English law.
Right, I've never come across it.
No, I mean, I would never. Mutual wills I have seen in English law. They do exist. I mean, rare. Yes, it is. What you're trying to do with a mutual will, you're trying to reduce the survivor to a life tenant over certain properties. So you're trying to use the mutual will in a way that you would use forced heirship regimes in forced heirship countries. That sort of makes sense. But we haven't got forced heirship, so therefore we use certain sorts of trusts to do certain sorts of things that forced heirship would do in civil law countries. And that's what the mutual will do. But I didn't think, before recent legislation in Guernsey, you sort of didn't need things like this because you had forced heirship doing what mutual wills do in England. We need them in England because you can't, other than doing it by means of some sort of trust in some sort of way, you can't reduce survivors to life tenants over their own property. But I didn't think Guernsey needed it. But of course, now you've got the new law. I don't know.
In practice, you do it by a different route. So if you are concerned that your much younger, much more attractive other half, when you snuffed it, is going to run off with a gigolo and not leave the property to half to her children and half to your children as you have agreed, you simply leave the property to them. To leave it to the children with subject to a life use agreement.
Yeah, that's right. Yeah,
or do I don't
yeah, because of course the trouble is we don't use usufruct. Well, we haven't got usufruct, but we don't use a life interest in the same way that you do in civil law countries in England. Well, you do. I mean, yeah, you do. Sorry, but it's a different sort of concept, if that makes sense. In that, it's a real right, and I'm well aware of that, but. It's not a trust interest, is it? That's the big difference, because in English law you make it a trust interest, so therefore you've got all the rights and obligations that come with the trust law, blah 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 blah. And it is, or it has been until fairly recently, so either strict settlement or trust for sale. Now it's a trust of land. So you can do things with that in a way that you can't with the usufruct in civil law jurisdictions, if that makes sense. Because it's a different, but it's a different sort of. Yeah. It makes sense in that you have fewer rights in relation to the usufruct than you do with a life interest under a trust in English law.
Right.
Does that sort of make sense? Well, you've certainly got some sort of, depending on what you've got some sort of interest in relation to the property. You could technically sell it. If you've got, I mean, you'd need, it depends how you set it up, doesn't it really? But you would have powers granted to you that I don't think you'd have under a usufruct in French law, or in Jersey law. This sort of, you've got the life interest, but, and you can, let's be perfectly frank, you are reducing somebody to a tenant for life over their own property. But I still think that the trust interest in English law is a stronger interest than the usufruct in civilian jurisprudence. I could be wrong there, but I don't think the usufruct is, maybe strong is the wrong word, but
it's fairly common to have a usufruct or a
yes, I understand that, but it's not in English law. It's not that common to use a life interest in English law. No, why would you use it? Because you've changed.
Just to protect the spouse.
Yeah, but English society's changed, hasn't it? So that if you may well have used a life interest, I don't know, a century ago, and it's been quite handy. But these days, most matrimonial property or quasi-matrimonial property is going to be held on some sort of joint tenancy. So therefore, you can't use any sort of. You can't use any, you've got an automatic accrual to the survivor.
But that's only if the legal title, but the equitable title you can sever. So the legal title you can never sever.
No, but it doesn't really matter, does it? Because what you've got in English law, which is, I mean, you're going to have it in Guernsey to a certain extent, is that you've got more and more joint ownership of matrimonial property and quasi-matrimonial property. So you've got an automatic accrual. I mean, you can have the automatic accrual to the survivor unless it's severed. And by and large, if you've got husband and wife or cohabitees or whatever they are, they're not going to be severing the matrimonial property.
They can though.
Well, they can. Yeah, they can.
But we've certainly
don't do it that often.
We've done it with a client whereby they bought their property jointly into the survivor.
Oh.
And then when we came to look at their wills, they were saying, well, it's not that we don't trust you to each other. It's just that I want to make sure that the equity in my house goes to my kids.
Oh, that's
and
different.
I'm happy for the equity in your equity in the house to go to your kids.
Yeah. Right.
So what they did is and you'll do this next week, is delaissance, where they sold the property to themselves in a different capacity for £1, and then did wills whereby they left each other a droit d'habitation over their half. Yeah. But you don't. I mean, I agree with you, and you do that on second marriages, etc., etc. But by and large, I mean, it's difficult to generalise. But where you have property held jointly, it remains jointly, and then it just goes automatically to the survivor. And that's one of the ways in which matrimonial, quasi-matrimonial property moves in England. It's not under the will at all. It's always by means of the joint tenancy. So I think Canny Guernsey would would be
Yeah.
more used
All
to
right.
using life interest.
No, you see, honestly, we do not use the life interest that much. You can use them, and you use them where you'd be using forced heirship in civil law. But by and large, bearing in mind that the matrimonial home is going to usually be the most expensive, the biggest asset people have got, and by and large, they want it to go to, the survivor. And they sometimes go on then to the kids, but you don't tend to sort of create trusts to do that. Honestly, you don't. We wouldn't sort of, I wouldn't sort of advise, how do you do it if you don't do a trust? Well, it's very difficult. There's not really any other way of doing it, to be perfectly frank. But I'm not sure I'd create trusts unnecessarily in English law.
A usufruct is not a trust.
No, it's not a trust, but we'd have to use a trust.
Yeah.
We haven't got a usufruct, so we can't use the usufruct because it's just not known in English law. So we'd have to use the trust, whereas civil law uses
Well, you've probably got all sorts of tax issues, haven't you?
Yes, to be perfectly frank, it's better to just let it go to the surviving spouse, isn't it? And then let them sort out the kids at a later stage. The danger is, of course, is that if that surviving spouse then marries, then the property, I think, and we talked a little bit about this and sort of mentalities of societies. I actually think that the English believe far more in freedom of testation than Guernsey does. I could be wrong. And I think it's sort of, it's not, we're used to it, I suppose. We've had freedom of testation for a good while now, since 1938, something like that. And I think we quite like that, whereas we don't like the forced heirship sort of concept. Oh, you've done both, Jules. Yeah. Oh God, yeah. No, the English just don't like it. They like to do what they want with their property. Yeah. No, I'm not. Yeah. I don't think they'll miss Oh yeah, Scotland is. I agree with you. Scotland's different again. Yeah. I'm talking about you what widens your horizons, yeah. Yeah, we don't use that. I think life interest would have been used far more a century or two ago. Preservation of large estates, but you don't bother to use them these days, where you're just talking about a semi-detached and Birmingham or something. Hell, why would you bother to put that on some sort of massive settlement? You just don't bother. All right,
But now, of course,
there's no point, is there? For inheritance tax, there's no point. Absolutely, I agree.
But that's gone now.
No, you just leave everything to your spouse. Well, for tax, depends on tax planning, doesn't it, really? But, or use into both gifts and hope you survive. Yeah, absolutely. You use that, but yeah. Anyway,
we don't have any of these things to worry about. But I think you're right that in Guernsey there is an expectation amongst the wealthier families that it goes down to the children.
I could agree. Yeah.
And spouses get they have a life interest.
Yeah.
Whereas I think in England it's much more, this is ours.
Yeah.
Yes.
And you'll get what's left at the end.
That's right.
The
Yes.
only thing I've seen that as a mystery is second marriage.
Yes, I agree.
If I would be concerned that I married, he slept it, and knew why would look after the children.
Yes, I agree with you there. Yeah.
That's the ordinary problem.
Yeah.
Correct.
If you were to have an average house.
Yeah. The problem is, I wouldn't sort of suggest, I'd be reluctant to use trust in that scenario because of the costs involved.
Well, that's why you'd use usufruct.
Yeah, but we haven't got usufruct in England. That's the trouble. You've got the usufruct, which is what's so wonderful, but we haven't got it. So we can only use the trust and sort of different trust devices of that. And then you're sort of thinking, oh God, would I bother? Because this is just an average sort of semi. in suburbia, would I bother, unless it's in London, and would I bother to start doing trust for this sort of thing? I'm not sure. Right, that's all that lot. We're going to whiz through that quickly because mindful of the time, we want to cover as much as we possibly can. No, hell no, we're not. No, we're not going to. No way. We've still got another 40 minutes. No, you're not on the chair. I said 2 hours. No, let's get. I think part of me thinks get the bulk of the work done out of the way, and then we've only got 2 hours after lunch. When I think right, that's formal validity. We have. Let's see what we've. Yeah. I don't think I'm going to go through revocation, alteration, etc. because we've sort of done that already. Okay, so we'll leave that one. Which brings us very nicely on to, which should bring us very nicely on to, yes, restriction on testamentary freedom. I suspect we'll start this now. We will not finish it, I would guess, before the lunch break. I could be wrong, but I don't think we will. Let's see how this goes. Okay, there's some history stuff at the beginning, I think, if I'm not mistaken. You can have a look at that in your own good time. I'll deal with that with you. What I'd like to start off with is, let's start off with Guernsey, because we're going to have to look at all jurisdictions. Excuse me. And let's have a look at the Law of Inheritance in 1954. And hope to goodness that we don't get any questions before 1954. Russell.
In practice, yes, you do.
Righty-ho.
So.
And then you might want to talk about.
Well, I think the only thing to summarise the history, customary law, for immovables, you couldn't do a will.
Oh, what, before 1954?
No, before.
When was the date?
So customary law.
When did that go though?
Customary law was tinkered with in 1840.
1840.
And so in 1840, they said, provided you were only dealing with ake, properties you would purchase, and provided you had nobody in your family within 2 degrees of relationship, which is very rare. So basically, you haven't got any family and you purchased the property, then you could make a will. And that was regarded as revolutionary. People in Guernsey weren't very happy about that. And so you had ratepayers of St. Peter Port rioting. This is true. And so they tweaked the law in 1847 to relax a little bit some of those restrictions on who can leave a will. But really, it wasn't until 1954 that you had the ability to make a will of real property in respect of your Guernsey site property. And there are restrictions in the 1954 law. And the restrictions are, in essence, that if you have descendants, and of course, in 1954, up until the 8th of May 2008, descendants meant legitimate descendants only. If you had legitimate descendants, then you could only exercise your right of testamentary disposition in favour of a very small class. And within that class, you could do what you liked. So number one was your spouse. You could leave your property to your spouse. You could leave your property to one or more of your descendants. So if you had 3 children, you could exclude 2 of them if you wanted to, and give it all to one. No.
You give it all to your surviving spouse?
You give all to your surviving spouse. Okay. That's fine. You could give it to one or more of your descendants and their issue. And of course, at that time, we were talking about legitimate issue. And in 1979, that class was expanded to include your illegitimate children and their descendants, your stepchildren and their descendants, and the illegitimate children of your descendants, your illegitimate children. So the illegitimate children of your illegitimate children and the illegitimate children of your stepchildren.
The illegitimate children, descendants, stepchildren,
And the illegitimate issue of your descendants, of your illegitimate issue, and of your stepchildren. But not, and I don't know why, but not the stepchildren of your descendants, the stepchildren of your illegitimate issue, or the stepchildren of the stepchildren.
It's in the notes.
It's in the notes.
It's in the notes, yeah.
But, and you could, so if you wanted to, in 1979, post, I think May 1979, you could, if you wanted to, leave all of your real property to an illegitimate child and exclude your legitimate issue.
Sorry, post 79.
Yeah.
Yes.
Post 79.
You can, so you give it to an illegitimate child and exclude your legitimate issue. Now, you couldn't exclude your spouse entirely because your spouse was given a life interest.
Is that even if you try to do it in the will, the spouse is right to do that?
Correct.
Yeah.
The trust.
Correct.
Yeah.
You could have an example where children inherit and we try to sell the right to pay
Correct.
You can't do it until the death.
Correct.
Or actually leave voluntarily, then life interest ends.
No, the income wouldn't it?
Yeah,
That's new.
but it's also the
That's
right.
right, yeah.
But it, well, it, yeah, but
Yeah.
but it's just sort of a usury, isn't it?
So under customary law, your widow or widower had one of two rights. The widow would have a right of douar, which is the right to a third for her life, and then the widower might have the right of frank bavage, and the right of frank bavage is a life interest, but it's
Yeah, no, it's life interest of all the
it's of all the property.
Oh,
I can't
all
remember
the-
whether it terminates on remarriage.
yes, it does.
It does.
Yeah.
So in Guernsey, douar was abandoned in 1954 in favour of the right conferred by Section 3 of the 1954 law. So a surviving spouse is entitled to the enjoyment until remarriage, though this is less generous than douar, which was for life, of 1/2 of the real estate of the deceased spouse. Then there was this weird provision which didn't make any sense.
No, it doesn't make any sense. The 100 and 200 quid one, that
Yeah.
one, yeah.
And what didn't make any sense was provided that if the annual value of that real estate after payment of debts is less than £200, the surviving spouse should be entitled to £100. But even in 1954, you know, any real property would be generating more than £200. So we thought that maybe what they meant by annual value was rateable value, but that doesn't make sense either. So we don't actually know what that means or meant.
I was going to ask you what that meant because I don't
Yeah.
understand what that meant.
And sorry, did I mention frank bavage? In order for the widower to be entitled to frank bavage, there has to have been born a viable child from the marriage. And this is where you get that weird idea in customary law, but I think it's weird, that you would invite your neighbours to the childbirth.
Yeah,
Yeah,
that's the
because
one.
and you have to you had at the time, and customary law goes into all this detail, that you had to have your neighbours witness the child take a breath once the cord had been cut in the light provided by 3 good candles.
Didn't necessarily, well, we don't know whether they had to sort of make a sound.
Is this something else because
But children would die
Well,
at birth,
yeah.
and often the mothers would die shortly
Yeah.
thereafter. It was a pretty gruesome thing. But if you had married somebody who had lots of property, you definitely wanted your Frank Bovage, so you were comfortable for life. Okay, so these are the rules that applied between 1954 and 2012 in respect of Guernsey real property, tweaked in 1979 to include illegitimate children. If the surviving spouse wanted to, if the spouses wanted to do so, they could go before the court, in the conveyancing court, and surrender their life interest during the lifetime of each other. That wasn't very common.
Yeah.
So the will of movables.
Mm-hmm.
So the will of movables, customary law always allowed you to have a will of movables. As we've seen, we've talked about the formalities required, which there aren't very many. And then you have the Guernsey law, which is the droit relative au meuble des pères et mères of 1930. And basically, you were given freedom of testamentary disposition in respect of all of that part of your estate which did not comprise the entitlement of your spouse and the legitime of your children. This is not because I'm either a member of CND or I like to say these. Assume that you die leaving both a spouse and issue, which of course we were talking about legitimate issue only in 1930 up until 2008. So your surviving husband or wife would be entitled to a third of your personal estate. Your children, legitimate issue, were entitled to their legitime, which was a third the estate, and you could do what you like. You could leave this to your boyfriend, your girlfriend, a cat's home. La portion disponible was a third. And if you wanted to, of course, you could say, I give, and it would be perfectly commonplace to say either I give my children what they're entitled to, I give the rest of my estate to my wife. So my husband would get two-thirds. Or I give my spouse their entitlement under Guernsey law, and I give the rest of my estate to my children. That would be perfectly common. If you had illegitimate issue, then you could always give them part of that to benefit from before 1979. After 1979, if you wanted to, you could say they could also share this.
You had to elect to do that.
You had to elect. If you said nothing, they got nothing. Right up until 2008.
And all of this is that any property held jointly.
Okay.
That just automatically accrues.
So-
and any real property or personal property.
So this is
No, this only- this is only
we're only talking
Yeah.
about les meubles, right? We're not talking about real
Yeah.
property. So you're quite right. If you had a bank account in the name of Mr. and Mrs. Smith,
Yeah.
and Mr. Smith stuffs it, it goes to Mrs. Smith by operation of law under the 1960 law.
And that would not be counted.
That would
No.
not be counted then either.
Yeah, so all of that goes,
That would
that's like, that dealt with separately.
that just comes
Yeah, so
out.
that's sort of a way of
before.
getting around this, isn't
Correct.
it?
And that was what we used to do.
And with real, the same sort of thing with partner.
So if I buy property, if I buy a matrimonial home, jointly for the survivor, and for the heirs of the survivor, I die first, then it would just go to her. It would be nothing to do with the 1954 law, regardless of my
Yeah.
will.
A half life interest, two properties, family home was joint at 5, and say you own in your own name.
Yeah.
Then your spouse would have a half interest in that property.
Yes.
And-
Or if
yeah,
I owned the matrimonial home in my name,
yeah,
because I inherited it from my grandfather, and this has been where the Clarks have lived forever and ever and ever and ever and ever, and her name does not appear on the title deeds, then my spouse would be entitled to the half interest.
and that's a real Guernsey customary law.
Well, no, the customary law bit was the
No,
duer of a
duer,
third, which is why if you look at old Guernsey farmhouses, there is always the house, and then there's the dowry bit where grandma used to live. And then if you did not have a surviving spouse, or you did not have children, you might think that the children, if you didn't have a spouse, the children get everything. Well,
Mhm.
that's sorry. We won't come on to in tests, but
This is all tested.
this is all
This is all
tested,
tested, yeah.
So if you had a will, you didn't have to say, I give to my wife or my husband his or her interest, or I give to my children his or her interest. You could say, I give my entire estate to the RNLI. If that's all your will said, what would actually happen is the RNLI would get this 1/3, and the spouse and the children would get their entitlement because it's theirs by operation of law.
Yeah, and even if you're intestate, it doesn't intestate.
We'll look at intestate in a bit.
Yeah, forget about it.
But I'm thinking that.
I mean, the truth is, you can do what you want in your will, can't you? But it will be reduced by either the kids or the surviving husband, wife, if you leave it all to the RNLI.
But you can only do what you want with
Correct.
No, but you can't. No, but you can leave. No, am I not right? You can leave the whole lot somewhere, and it's just you don't have the testamentary power to do that. So then the will is reduced, if that makes sense. So you could leave it wherever you wanted to.
Yes.
But because in France you can't necessarily do that. You can't necessarily leave it where you want, because if the notary is drafting it, he just will not allow you to do that. Whereas in Guernsey, you can do what you want, and you can give advice. Yeah.
I want to give the £75 to the RNLI, do that.
But-
when it comes to paying it to them, your wife
They will
gets
get
25,
That's right.
and your son will get 25.
Yeah, provided they bring an action.
Provided they say, oi, no, that's mine.
Yeah. If they don't, if they just leave the will as it is, it'll stand. Am I correct? Yeah.
Correct.
So you can sort of just.
Wait for life to
Yeah, that's right. Yeah.
Because effectively,
You've got to claim your.
you have to assert it.
Yeah.
It's your right to assert.
But if you were a charity receiving the income of
The capital of your, yeah.
of your estate, you would be subject to laws. How long does that assertion?
Ooh, how long have you got to?
It's your property, isn't it? So it's like its normal rules of prescription would apply. I don't know.
No,
Might be 6 years, might be 20 years. typically what you would do is, if you had a will that said I leave everything to RMLI, you would say to your wife and children, do you wish to assert your rights? They would either say yes or no. Yeah. Correct. But if you came to me and you said,
if I know that they've got rights, I don't really want to tell them about it.
oh, we have that happen all the time.
Yeah.
All the
Well,
time.
I would just wait it out and move it.
Absolutely.
Yeah.
So you had people who moved here in the 60s to avoid capital gains tax, and all their family were in England. And they said, well, I'm definitely domiciled in Guernsey because I don't want to pay inheritance tax. And you say, oh, good, in that case, you're subject to these rules.
Yeah,
I said, well, I don't like that very much. I don't want my kids to know about that. Well, okay. I hope they don't assert the right, yeah. Because then sometimes you might say, and this would be, you have somebody come along and say, I want my wife to have everything. And if you are from an English background, that might be perfectly normal. So you would write a will that says, I leave my entire estate to my spouse, if she survives me or if he survives me. I am aware that this exceeds my powers of testamentary disposition available to me under the law of Guernsey, but I earnestly request that my children do not assert their rights. Right? And that would be in fact, I think in our old Preston book there is a sample to that effect. And you just rely on the kids, and most normal families would probably respect the wishes of dad in this example and let mum live there, hoping that they'll get the house when mum travels. And of course, some families don't, and there's something to be stopped. There's always been an issue in my mind about, from an English tax point of view, assuming the children all live in England, and you have a will that says, I want everything to go to my spouse, and I earnestly request that my children don't assert their rights. Is that in effect a gift for tax purposes from children to mum? I think it probably is.
Probably is.
And I think that Her Majesty's Revenue and Customs don't understand Guernsey law enough to realise. So I'm not going to tell nobody if you don't. But so if there's no spouse.
Actually, Russell, could there not be? Because you don't have to accept.
No, you don't have to.
You don't have to accept.
Provided you just do announce all entitlement before it. Technically, it's not going to be yours.
Yeah.
So could you not get around it?
Perhaps. I don't. Yeah. Perhaps. I don't know.
No. Nobody has to accept anything.
So again, you could do if you wanted to. Let's say that my wife and I have had amicable separation and we're both living separate lives. You're the one paying. I might say I request that I leave my entire estate to my children. Aware this, I earnestly request my wife not to assert the rights. If there is no surviving spouse, either because you are divorced or because he or she shut off first, then the legitime for children is a half. And similarly, if you have no children but you do have a surviving spouse, then his or her is due a half of the estate. And so the portrait disponible in either case is.
So what happens in practice if now I leave everything to charity? I have a husband and kids. That estate is going to have to be administered within a certain period of time. Am I correct?
Okay, we do not have the year and a day.
You don't have a year and a day rule.
No. So the mors saisi le vif applies just as much to personalty as it does to realty. But the executor is a form of obligatory agent.
Because they're going to have to do something with the estate, aren't they? And if you're waiting, if everything's been left to charity and there are these rights in the wings, so to speak.
Yeah.
what advice do you give your executor then?
So,
So if you're saying more, so it'll go into the charities,
well, no.
but it won't, because you need administration.
So, if there's £1 million, I think that the wife, in this example where it's a husband who's snuffed it first, that £333,000 is hers from the minute he stops breathing.
Okay.
And that right is the children's. That money belongs to the children. If they acquiesce in that money going somewhere else, then so be it.
But if they don't, then it has to go to them.
Yes, it was their
As the
money.
executor, you don't have the power to.
No. But you've got.
If I was the executor in that situation, I would want to contact the wife, and I would want to contact the children, and I would want them to say, "I don't want that money.
Yeah,
Give it
that
to the
makes sense.
charity."
And then you can.
Because otherwise, I'm acting in breach of the duties that I owe them.
Okay, that makes sense. Okay.
So really, the difference between the test sector is that you get to you can do what you want with. I know the slightly different on the LPD.
The positive discipline need is indeed, yeah. So you can choose if you want to benefit people. You can do it out of the third if you're the first to go. Half if you're the second.
Oh, after the 2nd of April 2012.
Ignore all of that. You can do what you like.
Yeah, you can do what you want. New law, applies to testate and intestate succession. I think that's important. So if an intestate doesn't make reasonable financial provision for you, then you can make a claim under the new law. I think we'd better go through this new law in some detail. Top page 39, hold on, which is 6.1. Yeah, I think there's an important part there. Person who wants to, I think we've said this, but let's sort of draw it out again. Person who wants to avoid the provision of the 2011 law had to execute a will prior to the 2nd of April of 2012, which could be revised by codicil. And you said we have lots of people doing that, even if the codicil is executed after the 2nd of April 2012. That's when dealing with a client who has a valid will executed before 2nd of April 2012, necessary to consider whether the will ought to be amended by means of a codicil or a new will to be executed. Of course, if you've got the new will executed, then you're going to bring it within the new regime.
Yes.
Yeah, so it depends what the client wants and what advice you give them.
Equally, though, there was also the similar situation. So whereas you had die-in-the-wool Gurns who love forced heirship, don't like the uncertainty created by the 2011 law, there are equally people who perhaps loathe their children and who did not want to, or their spouse, who did not want to be subject to the old rules even before the new law came in. And from the date that the states passed the legislation, but before it actually came onto the books, if you wanted to write a will which anticipated the coming into force of the new law, you could stipulate in your will, I make this in anticipation of the new law coming in, and provided you actually lived until the 2nd of April 2012, then that will would take effect under the new regime.
So you drafted the will in 2011 as if it was 2012.
As if the law had
those kind of force.
What you couldn't do is draft the will in 2011 in anticipation of the new law coming in, and if the guy snuffs it before the new law comes in, that wouldn't work.
And what would they decide?
Intestate.
Well, they would have died under the old law, so it would have been the extent that the will was inconsistent with that, that would have applied. So it would probably have been a partial intestacy. or alternatively, the will
Yeah,
would
'cause
be
if that-
construed as if it was only applying to
Yeah,
the
so just
destiny.
going back to that, if you have a will that tries to get around those provisions.
Yep.
That fails, does that mean the will's not valid for what you do with LTD?
No, so the
No.
person with disability. So let's say I have a will drafted in 2011. I want the new law to apply to my estate because I'm going to give everything to the RNLI, and my will says I give everything to the RNLI, then a third of it would go to the RNLI.
Mm.
If you're in the old rules,
Yep.
trying to get right, you give it all to the RNLI.
Yep.
But well, so it's not that hard, it's just that the other 2/3 will take precedent over you giving the full.
Yeah.
value
So
of the
and
estate,
people
yeah.
and
So
professional.
it doesn't invalidate your will. Is that
Doesn't
right?
invalidate
Yeah,
will,
yeah,
and
yeah.
many professional
Yeah.
drafted wills would have been drafted on the basis that we're only talking about la pension disponible, because there's no point saying in your will, I give to my husband his rights and I give to my children their right, because it's going to happen anyway.
Yeah.
So the will might only say, I give my estate to the RNL. Because-
They would know that if they're only talking about that.
Correct.
where the tax
Correct.
is doing it.
That's not the practice that I would have recommended,
Yeah.
No,
Yeah,
and
but it doesn't
I
mean
didn't
the
do
will's
it.
invalid.
It doesn't mean the will is invalid at all. No?
Because on first glance, that to me appears that you're just trying to get there.
I mean, basically, a will can only be invalid either because it breaches formality requirements or because it breaches capacity type requirements. But just because a testator exceeds testamentary powers or does something weird and wonderful with their testamentary powers doesn't mean the will is bad. It just
No.
means the testamentary powers have been exceeded, and therefore, it's got to be, you've got to tinker with it. So
So
to
you
speak.
apply.
Yes, that's right. Yeah, I mean, really, pretty well the only way in which I can think of will not be invalid. Formality, capacity, undue influence, fraud, those sorts of things
Yes.
will go to the heart of the will, or not having animus testandi, that's the thing. Those will all go to the heart of the will and just strike it down, and then you've got fraud and testimony. But these things, I mean, they're not fatal to the will. They're just sort of they're problematic with regard to the powers.
Interpretation.
Yeah, that's
And
right.
it could also,
yeah.
I mean, so for example, let us say that I have a favourite child, and the way I would draft a will, I want to give this to my favourite child. So the way I would draft that will would be to say, I give to my surviving spouse her entitlement, I give to my 3 children their leisure team, I give to my favourite child.
Yeah, that's the way it's drafted.
They might not like it, but that's
Yeah.
there's nothing they can do about that.
Mm.
Older practitioners might have drafted a will that says I give my entire estate to which might lead to confusion if the oldest child in particular didn't appreciate that, hang on a moment, that's subject.
You see, I think that's poor drafting.
Yeah.
I'd actually say where all the bits are to go,
Well, I
even
would
though, yeah.
It'll always be subject to any formalities required by law.
Yeah, I mean, you can't get around any of that
Correct.
at all.
But I'm talking about 1940s, 1950s.
Yeah,
I would have done it like
I tend to do belt and braces all the time, so that avoiding litigation.
Well, in the good old days, we never had any of that.
You don't remember those?
No, I don't remember that. But I
That's
mean,
when they've come off.
for a long time, there were only 6 lawyers that, by law, allowed in Guernsey.
Really? Good Lord. Did
And
you
you
know
had
that?
to live in St. Peter Port, and you could not grow a beard.
No, I
I
didn't
think
know
they
that.
do.
I didn't know they had to go in.
Yeah, they had to live within the city. I have no idea. Well,
this was all
beards,
very
obviously,
rough.
because you're dishonest if you have a beard.
Yeah, of course, naturally. Right, I'm going to have to try and get that in the diary somewhere. Right, let's go through this law because it is relevant. Where should we start? Okay, we leave that Right, new law. I think we've said this before, but the will or the intestacy must not make reasonable provision for the applicant. And there are 5 conditions that have got to be met, as on page 46.4.2, in order for a claim to be made. Deceased domiciled in Guernsey after that date. Application must be made within prescribed time, and I've got a sneaky feeling we said that was a 6 months, sorry, from the date of death of the deceased. Applicant must fall within one of the categories, and we're going to spend a little time on those categories in a moment, and the will must not have made reasonable financial provision. And also put down there, this is a personal action as such. So if you don't successfully make a claim under this act and you die, your child can't inherit that claim, so to speak. Does that make sense?
No.
Yeah. Yes, it is.
It is, but I mean, the point is that if I am the disappointed heir, and I am disappointed my mum does not make provision for me as I hoped she would, and I start the proceedings, and then I die, my children can't just carry on that action.
Okay, let's go through the persons who can apply. Spouse, civil partner. Now, you might want to sort of comment on this. That includes somebody who is judicially separated, but I don't know in Guernsey whether property adjustment orders are made. They are.
It would be very, very rare.
I would find that very odd if there's a property adjustment order that's been made for somebody to then make an application under this act.
Unless there was some bizarre fact that I can't imagine. I can't think that a judicially separated spouse for whom an order has been made.
Yeah.
Because the order typically says that you have no interest in the other's estate anymore. I can't see why that person
No, I can't see why.
making an application.
No, I mean it's sort of coming within category 2 as well, isn't it? That makes sense. It's sort of the former spouses, which again that would be very rare for them to make applications under this law. Yeah. Also, I mean, I've had to go to English law at times for some of this.
Yeah, of course.
You know, I'm pretty sure Guernsey courts will apply English law here. Be wrong.
Well, when we cut and paste bits of English legislation, I think
What else you can do?
council will inevitably refer the court to the English authority.
Yeah, I would. So void and voidable. So it says here, under English law, person who comes within this category is also a person where there's a void marriage or where there is a voidable marriage, which has not. Has not been annulled.
What was interesting here, of course, is that we allowed civil partners to make a claim in 2011 before we actually had civil partners.
Yes, I noticed that.
Because we cut and pasted the English law.
Yeah, I did notice that. Former spouses and civil partners, again, where there's been a financial order made on divorce, I can't really see why on earth they'd then be allowed to make a claim under this law. And I think it's going to be extremely rare for that to arise. Third category, person who is cohabitees, basically, during the whole of the period of 2 years ending immediately before the date of death of the deceased, was living in the same household and as a spouse or civil partner of the deceased. Fine. I mean, that's sort of a reasonably recently introduced provision in English law, but has been pasted into Guernsey law.
Which is interesting because if the relationship terminated not by death, but just because the chap walked away and was a cad and a bounder, then the girlfriend couldn't make a claim. But because the relationship terminates by death, we're now creating a claim for her.
Yeah, that's because it's been just cut and pasted in English law rather than. Says here that there's got to be commitment to permanence, and the 2-year period. there can't be any separations during that 2-year period, or things like hospital stays, etc., etc. That's fine. A child of the deceased. Oh yes, also about the child of the deceased. Includes legitimate, adopted, on possibly, etc., etc. Now, until fairly recently, it was thought that it would have been adult children, beg your pardon, not adult children, infant children who would have been successful, yes, you're nodding, for a claim under this particular head until the good old case of Ilott and Mitson, which caused great controversy. That one, I don't know whether you're all aware of that case. Yeah, of course you are. Basically, they are gifts in Lady's will to animal charities, and then she disinherited her daughter completely. I think there was bad blood between them, incidentally. I don't think there was a long love.
Well, they hadn't been.
No, I mean, there wasn't a lovely relation. There's no loving relationship between the deceased and the daughter. I think it's pretty bitter, wasn't it? Yeah, it was pretty awful. Anyway, it goes right up to the Privy Council, which is a load of nonsense. Supreme Court, sorry. And I think it was the Court of Appeal decision that was probably the most controversial, rather than Supreme Court. Suffice it to say, the Supreme Court actually gave her 50 grand, or reinstated the order in the first instance decision. Sorry, the first instance decision was 50 grand for the daughter.
And legal fees about.
Oh, yeah. Yeah, all right. I don't.
In mummy's tummy.
Yeah.
So if you have been, so yes.
Yes. Baby in the womb.
So in order to be an heir, as a matter of Guernsey law, you must be two things. You must be, one, alive, and we take alive to include having been conceived, and you must be capable of independent life. So you must be born and take a breath once the cord is cut.
Yes, what have we got here? There's some comments from the Ilott case, which I just jotted down for you. They're from the Supreme Court, when they were looking at the claims of an adult child. And they said following factors relevant. Testamentary freedom should not be lightly disregarded. Which they did, like, yes, I agree with you then. Maintenance, should be, we'll come on to this in a moment. Could be the ordinary cost of living, or limited to, sorry. Maintenance can be paid as a lump sum. All right. Maintenance extends to the provision of real property. Life interest is more appropriate than an outright gift. All right. But that, remember, we'll have to go behind a trust, ladies. It's not going to be the use. Oh no, sorry. Brain's gone. Sorry, that I presume would be the usage factor, beg your pardon, in Guernsey law.
Or life interest.
It could be either, yeah. Sorry, the life interest, when we're talking about Ilott, would be the trust, but it could be wider, I presume, in Guernsey. The behaviour of the parties, yes. Estrangement are legitimate considerations, which they then ignored.
Yeah.
And gifts to charities should be respected, which they then ignored. So I don't know what to make of all that. I mean, that does come out of the Supreme Court, I promise you. But you know, I mean, what's rather surprising, there wasn't a close loving relationship. I think that's what surprised me greatly here. And when you're talking about the behaviour of the parties and estrangement, well, that was certainly estranged here.
The fact that she was on benefits.
Yes, I would agree with you. Yeah, I think so.
She was not away of the same mind.
Yes, yeah. No, I think, but it does, yeah, but yeah, I think that probably is a consideration the court took into account.
They probably gave her just enough money so that her benefits, but not so much money that she could do anything with it.
Yeah, that's probably right. Other category, persons treated as children of the marriage or civil partnership. And then, excuse me, any person not being a person in any of the other categories. So if you come within none of the other categories, you can't then throw the kitchen sink and try and come within category 6 here. Who immediately before the death of the deceased was being maintained either wholly or partly by the deceased. And we're looking at the deceased making a substantial contribution in money or money's worth to the claimant. Okay.
So the obvious example will be an elderly relative that you're paying for the fees.
Yeah, that's right. Okay, two-stage process. First of all, you've got to look to see whether, or the court will look to see whether the reasonable financial provision has been made. If it has been made, well, that's the end of the matter, really. And if it hasn't, then the court has got to consider other factors which we'll now go on to look at. You're comfortable with that? Again, I think a lot of this is just spotting it up, let's be perfectly frank, because it's the Guernsey law is sort of definite by and large. Anything that I shouldn't say this, but anything that comes over from England is a bit more waffly. No, I'm being quite serious. Think of things like Banks and Goodfellow. It's a bit waffly. Would you agree with me? You sort of learn it out when you sort of done it, sort of, oh, what do the facts say? Waffle, waffle, waffle. And this again is sort of, okay, learn it out, throw it back, waffle, waffle. Do you not agree with me?
Well,
I'm being quite serious, whereas I do think that Guernsey law, there's far more structure to it, and sort of, this is what it is. You've got to know the dates, you've got to know what's happening. Oh, I know this is Guernsey law, but it's been sort of taken from England. I think this is a bit more waffly in that, remember, you're relying, it's because you're relying on the court to make decisions where maybe the state could have made decisions.
In a smaller jurisdiction, in a large jurisdiction, you have courts deciding where the edges are.
Yeah.
In a small jurisdiction, you don't know where the edges are because courts don't actually deal with these sorts of cases all the time.
I don't think I passed. Is there a Guernsey court where financial maintenance is
I am not aware of any judgments on it. Whether there have been applications that have been compromised, I don't know.
No.
To be honest, I expected there to be heaps of these.
Yes.
Did you?
Yeah.
Well, yeah, I'm not aware of it. I'm saying there might be people where
Yeah.
Right. I anticipate that they will look at the English authorities with guidance.
I do as well. Because there's precedent in other areas, aren't there? Things like the capacity where they're perfectly willing to look at English authorities, where that's the relevance.
Yeah. And if you're looking to interpret a piece of legislation, if that legislation has already been interpreted, that format of words in another jurisdiction. Like that's why in trusts we have so many. We look to Jersey law because the words are very similar. Here we've actually, we have literally cut and pasted the English legislation.
But why reinvent the wheel?
Exactly.
If this is what you want to do, then why bother to spend 5 minutes on it? Well, okay, reasonable financial provision. There are two different standards. There's the surviving spouse standard, where for the surviving spouse, it's sort of maintenance plus more, so to speak. And the ordinary standard, which is the maintenance only standard. Although remember, you can provide the maintenance plus more in any which way you like, so to speak. And we'll come on to sort of how we might want to provide for it a little bit later on. General guidelines, matters to which the court is going to have regard. So let's look at these. And it's a balancing act, I think, looking at all these factors and trying to sort of weigh out what's happening. And before I even start this, I must confess, I think it's much easier for the court to sort things out and determine what should be what in a larger estate rather than a smaller estate.
Yes.
You've got a small estate, and I can't see how. I don't know. It's difficult to do justice to all claims, I suppose. Much easier with a large estate. There's more flexibility in what you can do. So let's have a look at these guidelines. Financial resources and the financial needs which the applicant has or is likely to have in the foreseeable future. Okay, I think they're all self-explanatory. Please ask questions if you want to, but make comments. Financial resources and financial needs which any other applicant has or is likely to have in the foreseeable future. So you can see it's a balancing act. Yeah, I've put down here English courts have looked at things like the applicant's present and projected income, marital status, how near retirement you are, bank overdraft, mortgages on property, etc., etc. All that, everything's in the melting pot, basically. Yes, if you've got a will there, and you not necessarily have a will, but the financial resources and financial needs which any beneficiary of the estate has or is likely to have. Okay, so you're looking at earning capacity, financial obligations and responsibility. Again, you know, it's a balancing act, isn't it, between A, B, and C? Okay. Any obligations and responsibilities the deceased had towards an applicant for an order. Okay. Yeah, I've put down here things like if the applicant is wife, husband, and you've got a marriage of 20 years standing as opposed to 2 years, and then the court's going to take that into account and say that the wife, husband of 20 years standing has got a better claim, I suppose, all other things being equal, than the wife, husband of 2 years.
It's the same. Basically, the question is, if this relationship hadn't ended, if it's with the spouse, if this relationship hadn't ended in death but in a divorce, what would we be doing? And again, the spouse of 20 years standing is in a better place to claim than the spouse of 2 years.
Size and nature of the estate, I've sort of alluded to that already, because I have told you that small estates, they have caused big problems in England, so I presume that they will cause similar problems here in Guernsey. I can't see why not. State aid, oh yes, the availability of state aid. I don't know what to say about that. The extent to which the estate can actually effectively contribute towards the applicant's maintenance. All right. Oh yes, costs. What do I say about this? Normally come out of the estate, and the problem, and this is what I hate about piece of legislation. You get an application under this legislation, it can eat up all these things. What's the point? That's the problem with this legislation. You're a litigant, aren't you, Paula? I can tell you're a litigant. And I don't know, this is why part of me much prefers forced heirship, because that's right, it is what it is, and there's not much you can do about it. And look, you can look for you can look for avoidance mechanisms, but you know.
I predicted that there'd be more cases. I predicted that this would be manna from heaven for the bar, but not for your average Joe.
Yeah, I just thought that.
Well, I'm glad to a degree that I've proved that is wrong.
The origin of the estate as well might be relevant. So you're looking, certainly in spousal scenarios, to see whether the spouse could help make the acquire the estate, I suppose. Physical and mental disability of the applicant and any social security benefits that they might be entitled to. The conduct, oh yes, the conduct of the applicant. Of course, this was really taken into account in the electorate, wasn't it? There are a few cases I've put down here. If the applicant's behaviour is repugnant, then the courts are going to be very reluctant to make an award in that person's favour. Particular guidelines, let's look at these: spouse, civil partners, former spouses, former civil partners. We've sort of alluded to this. The age of the applicant, the duration of the marriage will be relevant. Contribution to the welfare of the family and looking after the family. So, have they looked after the home? Have they cared for the family, etc.? The point that you made, Russell, about it ending in divorce rather than in death, that is very important. Persons living. Sorry, I think this is Oh, living together as spouses, beg your pardon, rather than spouses. Yeah, age of applicant, length of relationship, contribution to looking after and caring for family. A lot of that's the same as the previous one, apart from the length. Well, I suppose the length of the marriage is important. So the length of this relationship is important. Child or person treated as child of family. Yes. Now, I thought that pretty well the only particular guideline here is the manner in which they might expect to be educated or trained. So this really deals with infant children. This is why I think until the Illard case, I thought by and large it was only going to be infant children who make a successful claim. So education training, okie dokie. Where you have got somebody being treated as a child of the family, then you're going to look at the extent and basis of the maintenance and the length of time for which they maintained the child. Did they maintain the child knowing it wasn't their own child, for example, and the liability for anyone else to maintain that child? And that, I've mentioned the Illard case here. Apparently in the Illard case, the other beneficiaries, who were of course all charities, they had no expectations of losing that.
Well, they didn't know.
They didn't know, absolutely, yeah.
They didn't have long relationships.
No.
I mean, I think it'd be different, you know, if she went around collecting money, doing flag days,
I agree.
running the local branch of the charity. I think
I agree with that. And persons maintained as the deceased, maintained by the deceased, I beg your pardon. And I've got here the extent and the basis upon which the deceased assumed responsibility for the maintenance of the applicant, length of time for which they discharged that responsibility. That's all going to be relevant. And there's some cases there that you can have a look at. And as I say, it's just a matter of, I think, learning up these notes. I don't think they're difficult. It's just committing them to memory as such. Orders which the courts can make periodic payments. You know what that is? A lump sum payment. That's useful where I put down here there's a small estate, I suppose. Transfer of property. Okay.
periodic payments thing can be right pain though. If you've got an estate that, you know, is everything to my wife and then to my kids, and then you have to have an estate, you know, something that is drip fed to the boyfriend or girlfriend forever. You never have clarity as to what it is that the other heirs are going to get.
No,
the estate can't be wound up.
Don't know.
I'm not
Sorry, no, I don't know about that.
That was a last week question.
Oh yeah, well done, Russell. That's because
cut and paste.
Yeah, that's what I was going to say. Yeah, because you can do it under English law, therefore it's just been imported.
Yeah.
Oh, I didn't know that. So you can't make a transfer of property order, and you don't think so? Okay. Oh, I see.
So there's the try to do it, but it's
Oh, okay. I didn't know that. Okay. Settlement of property, bit of trust. A variation of a marriage settlement.
Yeah, you can.
Oh, right, fine.
But again, I think I'm not aware of it ever.
Okay. Creation, extinguishment, variation, usufruit, adaptation, lease, license, or other right of occupation in relation to any real property in the estate. Okie dokie. Interim orders can be made. That makes sense to me that interim orders can be made. Run over time. What time did we start this morning?
9.
Oh, all right. Let's just finish this and then we'll go to a break. I'm sorry. I didn't realise we'd run over. Property available for financial provision comes out of the deceased net estate.
Your net estate is not what you might think of as your net estate. We said before that joint owned property is out with, and it was, and now it's not. So the court can make an order that claws back into the estate jointly held property. So
Yeah,
you might
absolutely.
think that I'm going to look after my spouse by making sure that all our assets are in joint names, which was a perfectly common. If you didn't want the kids to have too much, you'd put it all in the name of your spouse. And now the children can say, no, I want more. Let me have some of the money that's in mum's joint account.
Yeah, because the joint accounts, joint everything was a way to get around things. You can't, everything's up for grabs now, absolutely everything's up for grabs. So even nominated, well, I call them nominated, but insurance,
Yes, if you have an insurance policy that does not form part of your estate. So you tell your employer, I've got a death and service benefit, for example, and on my death, I want that money to go to my spouse. Right, it doesn't form part of your estate, it's got nothing to do with your estate. The court can direct that money should not go to the spouse, but should go to a claim under part.
Everything's up for grabs, basically.
So today, I have all the cash I own joint account with my spouse.
Yep.
And I leave the property to my spouse. So it's in my name only. But I have children.
Yep.
They can
Yep.
make applications for maintenance.
If the court thought they should make an order, absolutely, Basically, everything's up for grabs. There's no way of trying to, I suppose, protect property from these applications.
This is why lots of people produced wills before 2012 to keep under the inflexible but certain rule, as opposed to the fluid but uncertain. That we have regime we have now.
No,
sorry, can I just finish? I think with the transfer.
Oh,
Right.
Okay. Also, and I didn't know that you made these that often in Guernsey, but you know, what do I know? Donati Mortis Cowsers. Oh no! Oh well.
Deathbed gifts.
Yeah. Oh, I think I'm dying. Russell, I want you to have a pen. Sorry. Donati Mortis Cowsers. They're up for grabs, Guernsey. You have the concept. Oh, all right. I didn't know that because that's also in the law, and they
Provided it's been effective.
Yes. Provided it's a valid Donati Mortis Causa, yes. I can't think of many ways you can get around this because there's also anti-avoidance provisions as well. We've got here any dispositions made which are intended to defeat an application, and the dispositions must be made within 6 years of date of death, with the intention of defeating legislation. They can be undone as well, which means that things like contracts leave property by a will.
When I read that, I went, "Who would do that?"
I agree with you.
I can't think of circumstances.
I have seen them in English law, but I wouldn't. And to trust them, fortunately, are also. I mean, that's the biggie, isn't it? Trusts can also be undone, so it doesn't really matter if you make survivors dispositions in survivors trust, testamentary trust, do what you like. They can all be brought back within the whether up to grabs.
Which is an interesting provision because, as we'll see tomorrow, trusts are otherwise, in Guernsey law, quite effective.
Oh, they're pretty good, aren't they?
Setting assets away from your creditors. Because provided, we'll look at the action before the end tomorrow, but provided you're solvent when you set your trust up, your creditors, your future creditors can't attack the assets that are in the trust. But this does allow a certain category of creditors to make a claim. But remember that again, this only applies to deceased who are Guernsey domiciled people. So if you have a settlor who lives in Ruritania, who sets up a trust with Intertrust in Guernsey, and he doesn't leave enough money for his kids, they cannot come to Guernsey and seek to invoke this law to set aside the
Mhm.
trust.
Hmm.
So if you're going to domicile and you set up a trust and do it right, but basically, and then you die, that trust can come back into your estate for the purpose of somebody paying the maintenance.
If you make it
Yeah.
within 6 years.
If you, yeah, date
Date
of death, with the intention of
with the intention of
defeating
defeating it.
claims.
Okay. So if,
Yeah, so I suppose if it's a bona fide trust and you
Yeah.
don't, then that's fine. Interesting. Probably, I suspect we ought to go to a break. We haven't finished this yet. What? Say again?
Yes, please.
Oh, right.
I've drunk far too much water.
What am I saying? When we come back after the break, we will continue with this because I think this is quite an important area that we keep popping up in the papers all the time. So there's still a fair bit to do. I think I'd like to do a couple of past exam paper questions just to show you that you can do them. We haven't got enough time. Maybe she was right in giving us 8 hours to go. And then I will definitely not do construction, rectification, etc. Let you have a look at that yourself. So it's straightforward stuff. Because yeah, you can always ask. Yeah, I mean, to be honest, it's very much, it's more of the sort of swat it up and throw it back sort of stuff rather than things like this where you have to sort of understand and apply. And I would like to, I don't know if I will get, but I'd certainly like to make a start on intestacy this afternoon. Otherwise, we're going to be very hard pressed with, I think it's 2.5 hours tomorrow or whatever we've got, and what we've got tomorrow.
The intestacy bit, particularly pre-2012, is the complicated
I
stuff,
love that.
which is why you will get questions on it. But in practice, it's unlikely, unless you've got a usufruct or some reason for it.
Not to
Because
business.
whereas,
Yeah.
so in practice today, you are very likely to come across wills or estates that are governed by both the new rules and the old rules. It is very unlikely that you're going to come across an intestacy now that will be governed by the old rules, because obviously people who die after the 2nd of April will be in the new regime.
Yeah, it's only when you've got that usufruct, isn't it, that's been created a long time. Yeah, I think it's only in those situations, and they often pop up on the paper.
If you have a will pre-2012,
Mhm.
it's then deemed to be invalid for lack of capacity or formality, do they die intestate?
Correct. They die then, and they die to
Intestate
intestate now.
now.
Yeah.
Yeah.
There's no way to see.
No.
Whereas if they're tested on rules, but they just think the drafting or it's confusing, they're still
They're still testate.
But you apply the operation of law first and then.
Yeah.
Okay, we will look at Alderney and Sark after the break. Okay, it's 1:30. It depends on you what sort of break you want. I'm not that bothered. Want a break, but you can either have them sort of rustles in half an hour or an hour. People don't care. Yeah, I mean,
Yeah.
is that all right with you?
Soon
As
we
well?
start,
Because,
soon we finish.
yeah, I mean, I think that's my attitude as well. That unless you need a long break, there doesn't seem to be any shops around here or anything.
There is a
Or is
shop
there?
opposite this college.
Is there?
There's a sandwich shop. But it's
I'll go
probably it's more of a Gimster's pasty shop. Rather than-
No, I'll get something out at the end. I can survive with another cup of tea, I think, or something. Yeah, all right, we're back at 2:00, and then we've got 2 hours. Are you all right with that? I mean, I know we've gone over by about half an hour, but we've still got a fair bit of work to do, and I am desperate to finish this, to finish in test, or to make a start on test, and we've got trust to do. Because I must confess, not a lot of trust pops up on this paper, but little bits pop up, if that makes sense. It comes into other questions, particularly the succession questions. But there's not sort of a full-blown trust question. Well, I thought that as well. I assume that you did a bit more trusts in the finance company. I don't know. Does anybody do that one? Oh, all right. Okay. I mean, I don't know. I think there was a bit more in that. I don't know. That's the case, all right. Okie dokie. Oh, sorry, I forgot that.